If your case is set for a pretrial, don't be alarmed if nothing much happens. A pretrial is simply an informal meeting between the prosecutor and the judge and the defense attorney to check the status of the case. The judge wants to know if the case is moving along, whether or not discovery has been filed, whether or not the state or the government has responded to that discovery by getting the evidence over to the defense attorney. The judge wants to know how much evidence there is, whether or not the defense attorney has had an opportunity to review it all, and whether or not there's any outstanding legal questions that may require another hearing, such as a suppression hearing or an evidentiary hearing, whether or not any pretrial motions are to be filed by the defense, and whether or not the case can be set for trial in a reasonable period of time. Some courts will have one of these, other courts will have several. Many pretrials that last over a series of months, depending on what jurisdiction you're in. You may not be a part of these pretrials, and they may not ever go on the record. You simply go to court, sit in a chair while your attorney goes in the back to discuss the case with the prosecutor and the judge, and then the attorney walks out and says, hey, here's your new court date, and then it will explain what, if anything, was accomplished that day. So generally speaking, not a lot goes on during the course of a pretrial, so don't be alarmed if not a lot happens with yours. If you have any further questions, feel free and contact our office or go through the frequently asked questions tab in the link that we've sent you. Thank you.
Same way we fight